so good day po taong bayan, and today po papag-usapan natin tong mainit na balita. Pero kung ikaw po ay isang Duterte or Fprrd supporter, this is not a good news po kasi unfortunately na-deny po yung current request for interim release ni Fprrd. Okay? So for today po, ang gagawin na lang natin, gagawa po ako ng 2 videos regarding this. So yung una po, explain ko muna sa inyo yung actual decision po ng ICC, kung ano yung mga reasons ng ICC sa pag-deny. And then yung second video naman po, i-discuss ko yung mga pwede pang remedy na gawin ni Fprrd and whether or not kung final na ba talaga yan. Kung let's say na deny ngayon, ibig sabihin ba niyan wala na talagang pag-asa ma-interim release. Okay? So i-base ko po lahat ng discussion ko sa international laws natin, specifically the Rome Statute po, which is the law po that governs mga kaso sa ICC. Okay? So before we start po, just a quick reminder lang po sa inyong lahat, huwag niyo po kalimutan mag-subscribe sa YouTube channel ko, i-like mismo po yung video kung magustuhan po niyo yung content ko, and if you want to support me, you may do so po by joining the membership, which I call the Associates for Truth. Nasa YouTube ko po yung membership na yan. Okay? Anyway po, start tayo sa discussion natin. So before ko po i-discuss sa inyo yung actual decision, magkokonting lesson po muna tayo tungkol sa interim release request para mas maintindihan nyo talaga. Okay, so for that po, we will have to go to the Rome Statute of the International Criminal Court, and to be specific po, Article 60 yung una nating titingnan. Okay, so kung makita po nyo yung Article 60, yung pinaka-title po niyan is the initial proceedings before the court, and then yung important po dito is yung number 2. So kung makita po ninyo, nakalagay dyan, a person subject to a warrant of arrest may apply for interim release pending trial if the pretrial chamber is satisfied that the conditions set forth in Article 58, Paragraph 1 are met, the person shall be continued to be detained. Okay? If not so satisfied, the pretrial chamber shall release the person with or without conditions. Okay? So in Tagalog po, ang isang akusado sa ICC, once na-aresto po siya, pwede po siya mag-apply ng interim release pending trial. So yan po yung ginawa ni Fprrd ngayon. Okay? So yung important pong iti-take note natin dito, itong Article 58, Paragraph 1, pag ito pong mga bagay-bagay na to, itong letter A, B, 1, 2, 3, pag hindi na to present sa situation ng isang inaresto sa ICC katulad po ni Fprrd, ang mangyayari po dyan ngayon ay dapat mag-grant or i-release po, i-interim release ang isang akusado. So kung makikita po natin, medyo mahirap po talaga magpag-grant ng interim release. Okay? So yung point ko lang po talaga dito, yung interim release po kasi hindi siya automatically ginagrant basta mag-request ka, kasi mas priority ng court yung detention, and yung pag-grant ng interim release is only subject po or will only be granted upon the compliance with very strict requirements, which is ito nga yung letter A and letter B, 1, 2, 3. So hopefully naintindihan niyo po yan. Ngayon papakita ko sa inyo yung decision ng court kung bakit hindi daw pumasa si Fprrd dito sa paragraph 1A and paragraph 1B, 1, 2, 3. Okay? So this decision po, in my humble and very respectful opinion, ay inaabangan talaga ng lahat. May you be pro or anti-Fprrd. Kasi of course, pag ikaw ay pro-Fprrd, gusto mo mag-grant yung release niya, yung interim release niya. And of course, if you are anti-Fprrd, edi you are also waiting kasi ayaw mo ma-release, diba, si Fprrd. But anyway po, going back, yung decision po na to is from the pretrial chamber 1. It is dated October 10, 2025 by the same 3 judges po. And then yung decision po na to, public redacted version of decision on the defense's urgent request for interim release and renewed request for interim release. Okay? And then, of course, as usual, like what we have already discussed multiple times, meron yan laging procedural history dito. Kung ano na yung, basically, ito po yung summary kung ano na yung mga nangyari sa kaso so far. So hindi ko na to iisa-isahin kasi hahaba po tayo masyado. Kasi this decision po has 23 pages. So madami-dami pa po tayong papag-usapan. So yung procedural history I will be skipping. Pero yung important lang naman i-note dito, 12 March 2025 was the date na si Fprrd was surrendered to the court. Okay, so 12 March 2025 nag-start, and then of course the parties filed their respective pleadings, yung request for interim release, so on and so forth, until umabot na po sa decision na to, yung October 10 decision denying the request for interim release. So if you want to read this po, itong mga ibang bagay, you may do so. Search nyo lang po yung ICC Duterte case update sa Google, and more or less po lalabas agad to siya. Then punta lang po kayo sa court records, and then yung pinaka nasa taas as of the date of this recording, October 11, 2025, makikita nyo po agad tong decision na to. Okay, so anyway po, ngayon pupunta na tayo sa actual decision. So di ba like what I explained kanina, pwede po mag-interim release based on Article 60, Paragraph 2 of the Rome Statute. And para po mag-qualify nga dun sa interim release ng Article 60, Paragraph 2, dapat yung Article 58.1 requirements fully makomply ng isang accused. Okay? So ngayon, ang una po nating i-discuss muna is yung requirement under Article 58, Paragraph 1, letter A of the statute. Okay? So papakita ko muna ulit sa inyo. So yung 58.1A, ito po yung there are reasonable grounds to believe that the person has committed a crime within the jurisdiction of the court. So yung issue lang po dito sa 58.1A, whether or not si Fprrd ba he committed a crime within the jurisdiction of the court. So ang sagot po ng ICC dyan, the chamber observes that the defense has not contested this point, and in light of the findings contained in the warrant of arrest, the chamber considers that there continue to be reasonable grounds to believe that Mr. Duterte is responsible for crimes against humanity. Okay, kaya po ako medyo natawa kanina kasi this is a very big error on the part of Attorney KAUFMAN and kung meron pa bang ibang lawyers si Fprrd. Kasi ang sinabi lang ng ICC dito, the chamber observes, na obserbahan po ng ICC na yung defense hindi naman kinontest yung paragraph, yung Article 58, Paragraph 1, letter A. Diba? So in short, it would now appear na may kinomit talagang crime si Fprrd kasi hindi po yun kinontest ng defense according to the ICC. So kung makita po natin, sa first requirement pa lang po, 58.1A, alanganin na agad si Fprrd kasi hindi po kinontest nung lawyers ni Fprrd yung whether or not may kinumit ba talagang crime si Fprrd. Okay, and the reason why I'm emphasizing this, kasi kung titingnan po ninyo itong 58.1, ang nakalagay kasi dyan, 58.1A and B. So when you say and, dapat to lahat sama-sama pumasa ang isang accused para mag-grant. Diba? Pero dito pa lang sa first requirement pa lang, alanganin na agad kasi hindi po kinontest daw ng defense. So may reasonable ground to believe that Mr. Duterte is responsible for crimes against humanity. So and then klaruhin ko lang din po, itong binabanggit ko, this is the decision of the ICC itself based po sa mga observations sila sa mga pleadings filed. So again, ulitin ko dun sa 58.1A, medyo malaking blunder po to on the part of the defense kasi hindi nila kinontest. Okay? So ngayon, punta po tayo sa next naman, which is the issue of whether or not may ensure ba yung appearance at trial ni Fprrd sa ICC case. Okay? And then yung sagot po dito ng ICC, the chamber recalls that Mr. Duterte has from his initial appearance contested his arrest and detention, qualifying it as a pure and simple kidnapping. Okay? And then, in addition, his family not only physically resisted but also publicly voiced criticism regarding his arrest and detention and demanded that he should be brought back to the Philippines. And then may specific example po na binigay yung ICC which was on July 19, 2025. Mr. Duterte's daughter, so si VP Sara Duterte, mentioned in public speeches the idea of breaking Mr. Duterte out of the ICC detention center and attempted to legitimize the court's proceeding against Mr. Duterte. And then may isa pa pong example, the chamber notes that Mr. Duterte's daughter allegedly indicated on 19 August 2025 that Mr. Duterte had told her that he wishes to return to Davao City should he be granted interim release. Okay? Moreover, given Mr. Duterte's position as former president, meron daw po siyang necessary political contacts, a network of support din po, yung mga supporters niya, and then including his daughter who is also the vice president, makakatulong daw yun sa pag-abscond or sa pagtakas ni Fprrd kung i-grant yung interim release. And then ito po ang isa pang important din i-take note natin dito, ang sabi rin ng ICC, ang sabi daw po ng appeals chamber is that yung Article 58.1b of the statute revolves around the possibility, not the inevitability of a future occurrence, and that any determination by a pretrial chamber of whether or not a suspect is likely to abscond necessarily involves an element of prediction. Accordingly, the chamber finds that Mr. Duterte continues to pose a flight risk and detention is necessary. Okay? So in summary po, because of all the love and support Fprrd is getting, mukha daw malabo siyang hindi maging flight risk kasi madami siyang supporters na pwede daw tumulong sa kanya tumakas kung mag-grant yung interim release niya, and yung daughter niya is also a person of influence being the vice president, plus the support din daw po of the people yung pag-elect sa kanya. So in simpler terms po, yun nga po, lahat ng pagmamahal at pagsusuporta kay Fprrd will go against po the assurance na hindi siya magiging flight risk. Yun yung rason. And may mga specific example din po ditong binigay talaga yung ICC. Itong sinabi na may public speech daw si VP Sara na itatakas daw si Fprrd sa ICC Detention Center. Hindi ko po nakita yung actual speech na yun ni VP Sara. So hindi ko po masabi kung joke lang ba yun or seryoso ba talaga siya. Pero anyway, ang point ko lang po dito, kung let's say joke lang yun siya on the part of VP Sara, dito po makikita natin na hindi maganda magbiro ng mga talagang importanteng bagay kasi hindi natin alam paano yun siya matitake into consideration ng mga korte like that of the ICC. Diba? Kasi posible joke lang to kay VP Sara na itatakas daw. Pero sineryoso po yun ng ICC. And we cannot also blame the ICC for taking that seriously. Kasi we have to remember, VP Sara is also the Vice President of the Philippines. Therefore, si VP Sara also has a connection and a network of support. So baka posible sigurong matakas talaga ni VP Sara kaya natakot yung ICC. So anyway po, dun sa 581B1, kung yung whether or not ma-assure ba yung pag-appear ni Fprrd, malabo daw po considering all the love and support nga, and then the actions and the statements din po ni Fprrd himself and that of his family. Okay? And then yung sinabi rin po ng ICC dito na important natin i-take note, pwede daw kahit mag-involve lang yung mga possibility or prediction, kahit wala pang actual na clear evidence ba na masushow na hindi talaga siya mag-appear in court, posible na daw yun maging ground for denial. Diba? Kasi ito nga, it revolves around the possibility only. Therefore, it necessarily involves an element of prediction. So, manghuhula pala tong ICC kung whether or not flight risk po si Fprrd. So, hindi ko po dinedegrade yung ICC when I say manghuhula kasi sila po nagsabi nito It necessarily involves an element of prediction. So, therefore, they are predicting kung whether or not flight risk ba talaga si Fprrd. So ito yung tungkol sa obstruction of justice, more or less, to ensure that the person does not obstruct or endanger the investigation or the court proceedings. So ang issue dito is whether or not mag-obstruction of justice ba si Fprrd kung makalaya siya or i-grant yung interim release request niya. So unang-una pa lang po, sinabi agad ng ICC dito, the question of the risk to witnesses and investigations revolves around the possibility, not the inevitability of a future occurrence. So again, kahit na hindi pa talaga sigurado, posible lang na magka-obstruction of justice, pwede na rin po bumagsak ang isang application sa interim release dito sa 581B2. Okay? So ang sabi po ng ICC dito, the chamber does not need to assess whether Mr. Duterte has actually taken steps to contact or exercise pressure on potential witnesses. Diba? So hindi daw nila kailangan yun na may actual nang ginawa si Fprrd kasi yun nga, diba? Possibility is sufficient already. Anyway po, going back, Mr. Duterte's and his associates' history shows that he is able and has means either directly or through his associates to obstruct proceedings against him. And then may sinite po silang example. Ito, Mr. Duterte or Fprrd's alleged involvement in briefing a witness due to testify before the Philippine Senate, as well as threatening and taking retaliatory actions against individual opposed to him, indicate Mr. Duterte's propensity to interfere. Therefore daw po, because of the past actions ni Fprrd, meron daw possibility na magkaroon ng obstruction of justice na gagawin si Fprrd. So kung makita po ninyo, so far, dun pa lang sa dalawa nating diniscuss, very important po talaga yung mga actions ng isang akusado. Tinitingnan po talaga yan ng court in relation to the requirement. Diba? So sabi lang dito, dati daw sa Senate, allegedly pa lang naman po, may nagkaroon daw ng coaching a witness, briefing of a witness, and threatening individuals opposed to him. So there is now a possibility na gawin daw niya ulit yun, grantan siya ng interim release. And it is for those reasons kaya bumagsak din daw po si Fprrd sa 581B2 requirement. Okay? Yung issue po dito is whether or not magtutuloy-tuloy pa rin ba mag-commit ng crime, ng alleged crimes ang isang akusado kung i-grant yung interim release request niya. And of course, alam din po natin na bagsak din daw po si Fprrd dito according to the ICC. And the reason po, yung in-example nila ditong binigay is that noong 2024 lang daw, Mr. Duterte also has allegedly pledged to double the killings if he were to be elected again as mayor of Davao City. And diba? And then sabi po ng ICC, the chamber recalls that some of the crimes alleged in the warrant of arrest were allegedly committed when Mr. Duterte held the position of mayor of Davao City. As such, should he return to Davao City, Mr. Duterte would be placed in the very position that allowed him to commit the crimes. Okay? So, ang point po ng ICC dito, isa daw kasi sa mga grounds na ginamit dito ng prosecution against Fprrd ay some of the actions of Fprrd when he was still the mayor of Davao City. And meron daw speech si Fprrd noong 2024 na dodoblehin daw niya niya yung mga pagpapaya pag na-elect siya ulit as mayor of Davao City. At dahil doon, since kasama yung mga actions niya, yung mga past actions niya as mayor sa arrest warrant, therefore there will be a chance daw na magko-continue pa rin siya mag-commit ng mga crimes that he allegedly committed. And therefore, bagsak din daw po si Fprrd dun sa third requirement sa 581B number 3. So, kung makikita po ninyo, one of the common denominators dito na sinight ng ICC paulit-ulit is yung actions ng accused himself. Even the past actions po of Fprrd was used against him. And the reason most likely kaya ganyan po yung setup sa ICC is because yung interim release nga is not automatically granted, diba? Ikaw yung mag-a-apply niyan, ikaw yung magre-request niyan. Therefore, kailangan talaga mas malakas yung mga ipakita mo sa ICC compared to the presumptions or the possibilities na meron yung ICC against the accused, diba? Because yun nga po, the granting of interim release is very rare in ICC cases. Therefore, dapat talaga magaling mag-explain yung abogado para lahat nga ng presumptions and possibilities ay ma-overturn in your favor. Okay? Ginamit din pong argument nila Atty. KAUFMAN dito na due to the current health condition, medical conditions ni Fprrd, yung mga requirements daw dun sa Article 58 Paragraph 1, letter A, letter B, 1, 2, 3, hindi na daw yun magagawa lahat ni Fprrd because of his medical or health condition. However, ang sinabi ng ICC, yung mga documents daw na yun, hindi siya napakita ng maayos kung paano yun maka-negate dun sa mga risks nga, sa mga requirements na diniscuss natin. Okay? And then, ang next po, ang sinabi din ng ICC doon, yung arguments daw ng defense who does not have the requisite expertise to draw such conclusion and as such are purely speculative and without basis. So, hindi siguro kumuha to ng expert testimony sila Atty. KAUFMAN kasi pag mga matters na beyond the expertise of a lawyer, kailangan po kasi yan ng ibang expert witness na mag-testify as to certain circumstances or facts, diba? Pag i-present mo po kasi yung isang document which shows the medical condition of Fprrd, yung document na yon pwede niya sabihin na meron, let's say, hypertension yung isang accused. However, the fact as to whether or not kung yung hypertension ba yun maka-apekto sa isang kaso, hindi po yun automatic agad. Kasi kailangan din magbigay ng expert testimony yung doktor at i-explain niya kung paano yung sakit na yon ay maka-apekto sa kaso. So ang sinabi po dito ng ICC, ang ginawa lang daw po ng defense, sila lang yung nagbigay ng conclusion na ganun. Eh hindi naman po doktor yung lawyer ni Fprrd. So dahil doon, naging purely speculative and without basis na yung mga medical conditions na nakalagay doon sa mga documents ay sufficient para mag-qualify or pumasa si Fprrd doon sa requirements for interim release. Okay, so stated differently po, dapat nag-submit sana sila Atty. KAUFMAN dito ng expert witness kung saan yung doktor mismo or yung expert na yun yung nagsabi na yung mga sakit na nakalagay dito sa document na to ay maka-apekto talaga sa kaso. Pero yun nga po, since wala nga daw pong ganun, yung defense lang yung nag-conclude, therefore naging purely speculative. So masasabi ko lang po, itong part na to, madali lang sana to ma-solve. But of course, bahala na lang po sila Atty. KAUFMAN dyan kasi siya naman po yung lawyer talaga ni Fprrd. And in addition po dun sa health condition and humanitarian reasons na ginamit nila Atty. KAUFMAN, ang sabi lang po dun ng ICC is that the chamber notes that the defense limit itself to argue that Mr. Duterte is 80 years old and medical reports have highlighted yung mga sakit po niya without substantiating how detention is so detrimental that it justifies his release. So ang point lang po nito, gumawa lang daw ng mga general statements or general assumptions sila Atty. KAUFMAN na si Fprrd being 80 years old as may sakit, therefore detrimental na daw yung detention sa kanya, so kailangan ma-release. So ito po, somewhat similar lang din to yung nandun sa taas na nakulangan ng explanation sila Atty. KAUFMAN, diba? Kasi if you just make general statements po, general assumptions, hindi po yan talaga tatanggapin sa korte kahit po dito sa atin, di ba? Kasi tatanungin ka po niyan palagi ng mga particularities or yung mga specific na nangyari kung bakit yung ganito will result to ganito. Hindi pwede yung magsabi ka lang tapos conclusion without an explanation, di ba? So yun po, ang sabi lang, there was just an allegation or a statement na si Fprrd is 80 years old and medical reports highlight lang daw po yung mga sakit without substantiating how detention is so detrimental. So dapat pinakita talaga or in-explain nila Atty. KAUFMAN, because of all of this, yung sakit ni Fprrd and his old age, magkakaroon or detrimental talaga yung detention sa kanya. Okay? And as final remarks po, ang masasabi ko lang dito, merong mga ibang aspects based from the decision rendered by the ICC. Ang professional assessment ko, parang nakulangan ng explanation sila Atty. KAUFMAN. Like yung sa Article 58, Paragraph 1, letter A, hindi daw yun kinontradict ni Atty. KAUFMAN or ng defense. Therefore, admitted na agad nila yun, yung 58.1A, di ba? So kung inadmit mo na merong ganun, edi bagsak na agad yung application mo kasi lahat po ng requirements na yun, yung sa 58.1A, pati 58.1B, 1, 2, 3, lahat po yun dapat pumasa ang accused para magrantan po siya ng interim release request. And then dun sa health conditions, di ba, sinabi po ng ICC na very speculative daw kasi sila, yung defense lang din mismo yung nagbigay noong conclusion, hindi naman po siya expert as to that field. Okay, and then yung isa pa po na gusto ko i-point out talaga dito is that big deal po talaga yung actions ng accused and those that are around him, di ba? Including his family, plus yung network of supporters po niya. And I'll be honest po, mahirap din naman talaga kasi i-balance yun. Kasi of course, if you are passionate about a certain subject matter, di ba yung tendency talaga ipaalam or mag-voice out ka talaga ng mga opinion mo or ng mga gusto mong ipaabot sa ibang tao regarding the subject matter po na passionate ka. So kung sa tingin po ng mga supporters ni Fprrd na kinote and quote kidnap talaga siya, edi talagang sasabihin yun ng mga supporters niya out in public. Pero yung problema lang po dito ngayon, yung passion at yung support at yung pagmamahal po ng mga supporters ni Fprrd sa kanya, yun din mismo yung ginamit ng ICC dito to deny his request for interim release. It was one of the reasons po for the denial, di ba? So yung next step na lang talaga dito, yung mga supporters na Fprrd, dapat mahanap po yung balance kung paano nyo mapakita yung support and yung passion nyo towards Fprrd and you're being against his detention without compromising po or affecting the case po ni Fprrd. Okay, so yan po yung magiging assignment sa lahat ng mga Duterte supporters, di ba? You should balance your passion and your support para hindi maapektuhan yung kaso ni Fprrd. Okay, so anyway po, hopefully klaro yan. After 1 hour po, more or less, next naman, i-discuss ko sa inyo yung mga pwede pang maging remedies ni Fprrd dito sa interim release request niya. Okay?